how do we feel as taxpayers if that is being used to purchase electronics and hardware that have been produced by child labour or sweatshop labour in parts of the world? I would say many people would be concerned by that. The second is just the legal play, because I think sometimes people look at human rights and procurement and think, well, this is all very nice, but it's all a bit esoterical, and it's perhaps a bit like the discussion on competitive dialogue or competitive negotiation. It's not really what gets litigated. Well, actually, it does sometimes get litigated. We have seen cases in the UK, for example, where procurements have fallen over. One procurement for legal services I know fell over because the procuring authority didn't think about the equality impact assessment that it was supposed to carry out under equality legislation. It was supposed to look at the way it procured, whether or not that would have an effect, whether it would favour one gender over the other, and it got successfully challenged. It also fought off in the same action, quite narrowly, a claim that the way it had structured its award criteria was actually, again, not promoting equality. So it's not true to say, well, this never gets litigated, it's all pie in the sky, it's not relevant. It can be. And just sort of looking at the legal framework we have, which at the moment anyway, we have the Human Rights Act, and Section 6 requires public bodies to observe human rights in the way they perform their public functions, and that includes procurement. We also have the ECHR, we have the UN General Principles, which again require public bodies to observe, promote human rights in the way they carry out their functions. So that's the legal side. The third main theme I would touch upon is the commercial one. Just to say, if we as a society don't monitor whether or not, for example, suppliers are complying with living wage regulation, minimum wage regulation, first of all, is that fair? Is it a level playing field? And what message are we sending to companies if we're going to reward that sort of behaviour? I think that's a dangerous step to take, and I think it is incumbent upon public bodies when they're looking at suppliers to really question, well, what I'm buying, is it human rights compliant? You can end up in a situation, for example, that effectively you're rewarding those companies that do cut corners. And in terms of the quality of what you're buying, would you be happy going into a hospital if you thought that maybe the cleaners who had been used by the cleaning company had been trafficked, were being overworked, underpaid? Maybe they wouldn't be in the best position to perform the best services they could, and maybe you have concerns about that. And I think this again goes back to your point, Roberto, that actually the two are not always disassociated, that if you want to get quality from what you're buying, that maybe these are concerns that are pushing in the same direction. So, I mean, just sort of 5 ways, in fact, that a public body can structure human rights concerns into what it buys and how it procures things. First of all, as I mentioned, I think it's important to structure the process in a way that is human rights compliant, consider issues like equality, sustainability in the way you put together award criteria, monitor within the PQQ itself and the qualification stage, are the companies concerned, are they complying with their human rights obligations? Things like diversity statements, are they doing those? Health and safety statements, are they doing those? That happens a lot in the UK, I'm sure, other EU jurisdictions as well. Think about where you're buying goods and services that are being produced from outside the UK. Are the workers, are the people who are involved in the process of manufacturing those processes, providing those services, are their human rights being looked at? Are the suppliers concerned monitoring those effectively? I think in the way that the contract is executed, you need to continue to perform a monitoring duty. Monitoring both in the sense of, is the supplier itself observing human rights issues? If they're looking after a care home, are they having due regard to the rights of the residents of that care home, all the people? Also, more controversially, the way that the public body itself exercises its own rights under the contract. The right to terminate the supplier itself, if that's exercised in a way that is whimsical, you might find a claim that actually you're not respecting the rights to property of the supplier itself. And I have seen that point litigated with varying degrees of success, but it is a consideration that needs to be borne in mind. And finally, if you're involved in the construction of infrastructure, etc., this might be an opportunity for you as a public body to look at things such as the right to work of young people and provide apprenticeships, and potentially, if you can connect it to the subject matter of the contract, to reward those suppliers who can provide apprenticeships to young people as part of the project. To talk very briefly about something that's happening in the UK, which I think is quite exciting and quite groundbreaking. Many of you will be aware of the Modern Slavery Act, which came into force here in 2015. And basically, what that does is it creates, in fact, I think I spoke about it the last procurement week, it basically creates a right, an obligation of disclosure on many private companies who've got a turnover in excess of £36 million, that they need to produce a statement saying what they do to ensure there is no slavery or trafficking present within their organisation or their supply chain. And whereas that's quite a minimal obligation, that is, I'm seeing it's having an effect, quite a significant effect on the way that private bodies are operating. They are asking questions of their suppliers, asking questions about their suppliers, where they buy their raw materials from, and what steps they take to ensure that they're not buying from products from slave labour, child labour. Interestingly as well, there's a proposal, I don't know if it'll go through, but there is a private members' bill currently before Parliament that would extend that duty of disclosure to public bodies and require them themselves to make statements about the steps that they take to ensure their suppliers have supply chains that are slavery-free, trafficking-free, and this is quite controversial. You've got many public bodies now objecting to that, saying, well, actually, we think that is putting a burden on us that we're not prepared to bear, and we think is better put elsewhere. But I mean, I think that's strange. You look to the public sector to set a good example, and I actually think that resisting that and generally disregarding human rights from public procurement means that the public sector risks indeed being left behind. Thank you.
So we're going to have a few comments from, but before we do, let's just sort of pick up where we are. I mean, we seem to have a sort of common sense of that these are important things we should be aiming for, but perhaps what I'm sensing is that we're trying to promote them in a number of different ways, and we haven't necessarily got a sort of uniform, coherent framework for deciding how are we asking for these things. I mean, one of the problems I have, and I will just throw it out now, is are we saying this is something for specification? If it's a question like fair trade coffee, which we all know, read to tell everyone about, fair trade coffee in a sense is easy because assuming that you have a reasonable means of measuring, of assessing it, you simply have the mark, someone goes and checks whether it's fair trade or not. You have your slavery situation, Paul, and in a sense, if you show you have a compliance system, well, maybe that works. The difficulty, it seems to me, can come at the next two stages. Firstly, if you're going to start using it as an award criterion, you then get into measurement difficulties, and certainly some of the frameworks I've seen seem quite scarily subjective. Sometimes a little bit akin to what I used to see when we were buying clothing for the MOD and so forth, where you get sort of tests about how itchy is the shirt, and you wonder, well, how am I going to measure the comfort of the shirt? And then in contract performance, you've touched on it as a difficult one. How do you decide? Are you simply going to say it's always, in English law, it becomes quite a difficult question as to what sort of breach of this obligation warrants termination? Because we know perfectly well, quite often courts will say, well, that's not a breach that warrants termination. They'll bend over backwards to prevent the termination from taking effect. But in the absence of termination, there isn't really any remedy for this at all anyway. Anyway, I sort of throw those preliminary thoughts out. Let's continue the discussion. So to comment and take further, who wants to go first? We've got Professor Sundstrand from the University of Stockholm, Professor Dragos from, I can never pronounce the name of your university, I'm sorry. Babos Boye, they're from Babos Boye University in Romania. Who's going to go first? Andrea?
It's good. I can go first.
Yeah.
Well, thank you, and thanks for inviting me. I have the very pleasure of commenting on everybody else. I just have to start by saying that I've actually now worked full-time with public procurement since '94, so that would be 23 years, I think. Mm-hmm. And when I started with public procurement, it was obvious that we were so into that you wouldn't even think of or dream about making demands on social issues or even environmental issues back in '94. Because then we thought the only demands you can actually make in a public procurement was all economical. So we have seen such a development of these issues during the last 23 years. So it's really incredible. And as we've heard many people said here today, that of course we cannot not take such a considerations in public procurement. It would be terrible buying goods from companies who their workers are getting poisoned or don't get fair treated and so on. So I think it's impossible for us not to make such a demand in public procurement. The interesting question is, how are we going to make it in order not to scare away too many suppliers? In Sweden, actually, we have, for each public procurement, we have an average of 4 tenders. Now, that might seem to be a lot, but that is considering an average. So in the north of Sweden, we often have a problem. We don't even have one bid for a tender in a public procurement, which means that the more demands we start putting up, the fewer we have will go away because not even them will be able to fulfill the criteria. So that is something you have to consider, that of course we have to have social demands for public procurement, but you have to balance these against what the suppliers actually can do. So it doesn't get too, we can't create a happy Disney world just by putting up these demands. So there have to be a reason to them also. That's what I want to start with saying. When it comes to principles versus rules, the first speaker, I just want to say that who could bid? In Sweden, we are Vikings. We've always traveled everywhere, and we like trade. We like free trade. So even from the beginning, when we started with, when we became members, 95, we decided that we wouldn't stop anyone from giving a bid in Sweden. So even if there was a supplier coming from March, we would say, great, come. And we even give them the same remedies as our Swedish or European companies come. And we have had no problem whatsoever with this. So that would be something for thinking about Brexit and further on. Why would you stop anyone anyway? As we say in Sweden, if they're so good that they come there to a foreign country and they actually win the bid, what competition do you have in the house anyway? So that's our opinion on that. When it comes to equality, I'm thinking about equality between women and men. And actually, if you look at the cases like Concordia or the Dutch court case, what the European Court of Justice is doing is referring back to the Article 7 to 13 in the functioning treaty. And that is actually where the policies of the European Union is set. We have social issues, we have equality, we have environmental issues, we even have, we should take care of dogs in space, more or less, agree with that. And what they're saying there in Article 7 is that these policies should influence everything we're doing. So, and that is what the European Court is doing, both in Concordia, Evian, Lindström, and so on, when it's saying, yes, the connection is there, that is necessary. We can't ask suppliers to promote penguins in the Arctic, which would be kind of costly. But at the same time, we actually have an obligation to take care of these issues also in public procurement, which is kind of interesting. So that's about equality. We have a problem in Sweden when we think that there are too many men in boards in the boardrooms of companies. So me and a friend of mine, who's a lawyer also, we thought maybe maybe we should have a new rule in Sweden saying only companies will have equality 50-50 in boardrooms would in the contract. Unfortunately, I think we realized that that wouldn't be enough connected to the subject matter in the contract. On the other hand, if you have you're going to buy a service performed by 10 people, you would probably be able to say that half of those we want half of them to be men, half of them to be women, because these are actually the people doing the contract. So that would probably be possible to do under the EU directives, I think. She didn't dare to because she works at a big law firm. She was afraid what her clients would think. I'm a bit disappointed. Right. The cost, I'm not going to go into that too much. I just think it's impossible for us not to do whatever the cost is. But it has to be reasonable demands. Coming back to remembering that the suppliers actually have to be able to also perform these things we are asking them to do. And the last thing was human rights. And at the same as before, these are actually one of the in the treaties that we had to implement in all our policies and all our doings in the European Union. And it's been even more emphasized within new directives. And I think this is right. Who wants to buy from child labor and so on? So I don't think we have an option here. But we have to do it in a good way. That's the issue. Thank you. Okay.
Thank you. I will take over. Well, as a first here, perspective from Eastern Europe, new Europe, so to speak. Well, I will look at these issues that we discussed already here from this perspective, because European directives on public procurement are meant to fit the purposes of Western Europe and Eastern Europe alike. Sometimes the interest and of course the traditions and the readiness to deal with these directives is so different. You're talking about aims, the public procurement. We're discussing about sustainability, anti-corruption, competition. This is so much more important in a country like where I'm from, where you have the courts, the review bodies, even contracting authorities trying to understand what is public procurement all about in the end. And it's so important to establish what's the first principle, what's the second principle, or the third principle to apply. Not only principles, but which principle goes first. Because, for instance, in a country like Romania, we have contracting authorities dealing with procedure and then being controlled by, in an ex-ante control procedure by the Agency of Public Procurement. During the procedure, maybe they are assigned some observers, because in high-value contracts, in European structural funds contracts and so on, they are assigned observers. So somebody from the agency stays with you during the procedure and gives you recommendations. After that, maybe you're selected for an ex-post control from the same agency. After that, if you had a European funds project, that you're controlled by the management authority, who deals with public procurement, and they feel very knowledgeable about public procurement, about principles and so on, and they are applying sometimes the principles against whatever the Agency of Public Procurement has said before. So that doesn't cover you. All these, controls do not cover you in any way. So you get a lot of, maybe sanctions from these authorities. And in the end, maybe you got an audit, the auditing company from the ministry or something like that. And of course, the Court of Accounts comes and even controls the discretion of the public authorities, and saying, well, you shouldn't have bought that or that. That's not a valid reason, the strategic reason, the social, the environment, That's not okay. This is taxpayers' money, you know. So with this fear of interpreting the rules, we are still facing this dilemma of having principle-based regulations or more regulations, because in some countries the anti-corruption idea is what prevails. So that's the only reason to have rules in public procurement, not to have corruption in spending public money. And if you interpret everything in that paradigm, of course the results are so much different. So maybe we should discuss this, because the directives have to fit all countries, and maybe we should discuss also this perspective of having principles and rules. It's not, wouldn't be so much easier with the principles. Even the rules you can interpret differently, the principles even more. So we should at least agree among us, those who are dealing with public procurement in a more organized manner, which are the principles that come first, because otherwise it's just gonna be a mess, a continuing mess. So that's one thought. Okay, then on the principle-based and rule-based regulation or systems, maybe one question would be, wouldn't this principle-based regulation or systems be transferring the burden of interpreting the principles to the courts and the control bodies more than the contracting authorities? Because in this rule-based system, you give more confidence to contracting authorities to act in a certain way. But in the other system, you empower courts, and in the UK it makes sense. But in other continental systems, it's a huge burden for courts who are feeling reluctant to go into the discretionary power of public authorities. So it will change a lot, even the way of thinking of the courts. That would be another idea. Then, of course, the strategic aims for public procurement. Again, I'd like some discussions about conflicting strategic goals. For instance, in some areas, even in Romania, we feel that, we don't have so much pollution. Why? Because we don't have industry. The economies have, although the industry has gone, we didn't build anything new. Mm-hmm. You know, we are just a market, maybe for other Western economies. So of course we don't have pollution because of that. That's not the right setting. So when maybe setting the specifications and trying to develop the community, some mayor or some local council, they will think, well, what should we go for? Having a new, factory built in the city and maybe putting in as technical specifications or criteria, employing long unemployed people or persons, or should we not encourage industries because they are polluting and we want fresh air and so on, maybe less industries. So again, we could have, even within the strategic objectives, some conflicting objectives. Then about the equality and respecting equality during the procedure and afterwards, and in the suppliers. Another idea would be to discuss the market consultations in terms of equality, the prior market consultations. Even here we have a lot of interference between for instance, the competition councils in some countries who feel that any kind of market consultation can lead to fraud, collusion, and so on, because you are giving the opportunity of private companies to meet and to elude the law and to participate in bidding and so on, which is a little bit of exaggeration from my perspective. But again, about sustainable, I already discussed that. Another idea that I would like maybe to stress more, it's like it was discussed in another panel, what's more effective for a government to use public procurement for innovation or state aid for innovation? Are these comparable? What are the pros and cons for using each of them? Because in that setting, we can think about more about our issues in public procurement, maybe comparing with state aid. Okay, I will conclude with again stressing the importance of considering the specifics of member states when discussing about future regulations and future developments in public procurement law. Because maybe we are not, for instance, in eastern part of Europe, we are not so prepared to deal with sustainability, with strategic procurement and so on, looking for innovation. But for instance, we are more than ready to deal with electronic procurement. It was discussed here that some communities will open up to other bidders from other communities because of the electronic procurement and so on. Well, in Romania, for instance, we are doing most of the procurement online. This doesn't save us from corruption or everything, because there are new methods and new techniques to try to engage in corrupt practices. But you can imagine that even for direct procurement, you go out and deal and negotiate with some supplier and then ask them to put a bid online, so it's traceable. So online procurement is not a new thing in Eastern Europe. It's done at a larger scale, and of course you get a lot of bidders from everywhere coming in. And of course, in Romania, for instance, we expanded the directives down to 30,000 euros to a national threshold. So everything is online up to that, above that level. So maybe in this respect, the more readiness of some countries to adopt these strategies, like electronic procurement, could be also a factor to consider when, again, redrafting the directives or reconsidering them or relaxing the rules or putting in new ideas and new paradigms. Thank you.
Right, so we've got a few minutes for questions, but shall we try and take 2 or 3 together, so I'm sure we've got at least a question or 2. No questions? Yes, Ed, please.
Question for Simon touched on, that both equally regarded as the legal profession might have a view. It was the point about courts being willing to insert themselves into the role of contracting authorities actually get into the business of rescoring. It feels to me that this is a newish development over the past 4 or 5 years. My question is 2 parts. Easy, and if so, what do you think? Yeah.
Do you want me to deal with that first one? Oh, sorry, you're going to take that.
Can we just see if there's any other questions? I mean, we might just sort of get right.
Yeah, I've got a comment / question for someone as well. Someone, you're saying that effectively today there's no litigation about the bread and butter of procurement, the more common rules, timescales and procedures, and that's not, and those kind of things. And from what I got from your presentation, then the disputes are actually about the areas where there is uncertainty and where there is discretion given to the contracting authority. Wouldn't that be the case that if we move from a system that is rules-based to principles-based, that you have more scope for litigation, because then you don't know what now is, for example, a deadline of 30 days might become a reasonable timescale, and then you go to the court and litigate about what is a new principle and what is reasonable, instead of having a very clear rule like you have today.
Mr. Chairman, I heard you make an opposition between those politicians and efficiency. Because well, they're politicians and they have goals and they use public procurement for their goals, even when it's not efficient. What can be the criterion for efficiency beyond political goals? They're chosen when they have a majority, they form the government, they start to execute their program, And then there is a procurement lawyer saying that's not efficient. That is strange. There cannot be a criterion for efficiency beyond the program which we have chosen. I think.
Yes, hi, my name is Miriam from Monckton. My question is for Mr. Henry. You mentioned about the trafficking in procurement, and quite recently I've been looking at what the US has been doing to prohibit trafficking both in the US territory and outside the US territory. And one of the things they do, especially for procurement from outside, is to ensure that the contractor or the subcontractor provides a certificate of compliance. Now, my question really is, what else, apart from the sort of legislative measures, can we impose to ensure that our contractors or subcontractors are not involved in trafficking free the contractor roles?
And your hand up. I think we've got a bunch of questions, but I think those that we can carry on.
Thank you. My question is, like, can we basically go from the e-procurement and bridge that with the other questions that were mentioned, the human rights, the equality, the sustainability issue? If e-procurement something, and even the principle-based versus regulation model, is that our practical tool where we can basically say it doesn't matter whether the directives are complicated or not, or principle-based, we have an e-procurement system that's our practical tool, and as long as that works, we're fine. Can we say that e-procurement actually, if we can tick a box and say we're doing something for equality, we're doing something for the environment, does that incentivize this kind of thing? So bridging the gap there.
Okay. What I'm going to do in a minute is just to ask everyone sort of in turn to, in 60 seconds, to pick up whichever part of whichever question you choose, and then we'll see what hopefully will cover it. Let me just add in one thought. We haven't actually mentioned the words Regio Cost and Profit in this debate, and I sort of saved it till the end, but not least because Albert had an entire day on the subject, and so only recently. But I mean, I suppose one of the questions underlying all of this is the extent to which that represents a judicial indication of how you deal with policies in tension, and there I suppose, I mean, many policies in tension, there I suppose it would be internal market and labour policies, and that tension certainly is very acutely felt in London, and it's something which local authorities here are always balancing out how you deal with that internal market versus the labour policies that you involved. So, should we start with you, Simon, and then double back and then go down the table? Is that okay?
Yeah.
Simon.
Ed, in response to your question, what's brought on the courts reviewing discretion of contracting authorities? I think there are two things. One is the disclosure system we have in the UK, where you find out everything and see all the emails, and as a claimant, you uncover all sorts of dirt, and very often the dirt that you uncover is not corruption, but it's really poor practices around, in particular, record keeping. And I think record keeping is at the heart of the problems that arise again and again. I think the solution lies therein. So in Geodesign against the Environmental Agency, for example, the decision to eliminate my client in that case was the reasons for it were written on the back of a diary, on one page of a diary, and scribbled in notes. And the judge therefore felt it incumbent on himself to analyse very closely the rationale for the decision, because it wasn't properly recorded anywhere. So I think that's the answer to that. Pedro, you're suggesting that I'm making a self-serving argument to provoke more litigation.
Your words, not mine. Your words, not mine.
My view on this is that a lot of the EU litigation, like Woodford, etc., that we get, is about the difficulties you face over balancing the prohibition on indirect discrimination between member states against legitimate policies such as social policy, which is part of the EU treaty. It's very complicated and it leads to all sorts of difficult litigation. And I just question whether we really need that degree of prohibition on discrimination, whether we can go for something a bit more simple and just focus on prohibiting protectionism where you've got reciprocal market access. So I think you could simplify it that way. And just lastly, I don't think it makes any difference in terms of sort of litigation on principle-based stuff, like the fact that there's no record for a decision and it looks wrong-headed. I don't think it makes any difference whether you have a book full of rules or whether you just have a paragraph of principles. You're still going to get that issue litigated. What you really need is proper records.
So we've got other issues to cover.